She was given immunity, though. Let me bring in my guest, criminal defense attorney John Mobley, to talk more about it. John, what are you thinking, watching her testimony and hearing the facts that came out?
Well, I think he made the points he needed to make. I think he was not going to shake her on it happened, on saying it didn't happen, because, I mean, honestly, her testimony is fairly innocuous. Even though I don't like it coming in, it's fairly innocuous when I say that it doesn't really hurt the defendant. So I don't think any points are to be scored by trying to attack her credibility for, saying it didn't happen. But he made the important points that she never observed any inappropriate relationship between Sherry and his client, that at no point did she observe Sherry during these conversations, tried to elicit his client to engage in inappropriate conduct or discuss a murder or a plot to kill or discuss revenge or trying to take him out. So those are the main points that he needed to make, and I think he did a good job of bringing those points out.
Yeah, most definitely. Tell me what you think about the fact that this jury is sequestered on this one. Is this a good thing in your view?
Well, I think jury sequestration is always a good idea particularly when you have a high-profile case, because you can tell a jury not to follow the case, not to do an investigation, but they're going to do it. And they don't have to go into their PC. They can do it on the telephone. It's just human nature to look things up about a case to try to find out more. And, of course, they think they're helping. They think that they're trying to get more information to make the best decision. So they're going to get on Google and Wikipedia, and read all these different, news sites with different perspectives about it. And I think that could certainly taint their ability to make a decision based on the evidence in the trial, as opposed to all these other conspiracy theories. Because, in every case, there's always conspiracy theories that, there's someone that said this that never got a chance to testify, or there's a rumor that this was some part of the evidence that was never included. So I think it's a good idea to do that, particularly if he's going to limit their access to web and news feed services.
Right. Yeah, I was very pleased to see that, especially because this is a very high-profile case. In that area, we know Lorenzen Wright was beloved. I mean, really seen as a hometown hero. Our Court TV crew, got there over the weekend before the trial began. It was talking to different people, fans, people who just knew all the good he did for the community. And you heard his mother sharing with Chanley. We played a little bit of that interview back today on the program, how he was doing so much good even before he rose to fame and amassed a fortune from his time in the NBA. John, tell me, how does that factor in to the trial? The fact that the victim here is a celebrity, an athletic superstar, and there may be people in the community who really feel for him that might have been summoned for jury duty. How does that affect things if you're on the defense side of the case?
Well, that's definitely an intangible that is not favorable for the defense, because, you have a situation where the jury wants to find somebody responsible. They want to hold somebody accountable. So whenever you have a victim that is beloved in the community, that is always a negative factor, because they want to bring that person justice. They want to bring that person's family justice. So that's definitely something they've got to contend with. I guess the other question is, how well known is, well, I guess he's probably not too well known. The defendant is in the community. He's probably not very well known at all. So I don't think he's going to have anything he can really balance that against, with these particular facts.
Yeah, right. I mean, who knows? I'm sure they would be asked. Obviously, one of the standard questions. And for our viewers at home, right, one of the big questions, anytime you've got the jury pool, do you know any of the parties? Do you know any of these witnesses? All of that. So if somebody would have gone to his church or something, that would have been flagged early on, or we would hope so.
Assuming they told the truth, what they don't always do.
What's that? They don't what?
Assuming they told the truth, which they don't always do.
Yeah, right. I mean, we're seeing that come back in some of these cases that we've been covering. The Ghislaine Maxwell case comes to mind, when during the voir dire process, that juror did not disclose being a victim of a sexual assault, and then did media interviews after the fact, and then talked about...
I actually had an experience in a homicide case that I tried where it was a very small town, a very high-profile case. A lot of the state's witnesses were well-known local in the community, and no one in the entire jury panel stood up when asked if they knew any of the witnesses in the case, and it blew my mind. And I was, and I'd never done this and had it happen before, but I actually asked the judge to do individual voir dire. And although no one in the panel stood up, 15 people indicated they had relationships and knowledge of the witnesses, once we took them back for individual voir dire. Yeah.
John Mobley, you are so smart. Well, we know you're so smart. That's why we love having you as a guest on Court TV. But to do that, right, to not just accept the group answer, which was everybody quiet, crickets in that room, you had the judge.
It just made no sense.
Yeah.
It made absolutely no sense in that small community.
Right. Well, and do you find this, I know I found this as a prosecutor, when you're in voir dire, and every state does it differently, the setup can be different in every single courthouse, but generally when they're in the group setting, people aren't as likely to speak up or raise their hand. When they get to the table with you and it's more intimate and you're sitting there with, opposing counsel and the judge or whomever's monitoring the jury selection, then they're willing to speak a little more freely.
Yeah, and what I frequently do when I have cases like, any type of trial, I have two concerns. I have the concern of the juror not being comfortable speaking about something. The second concern is a question that may be asked to elicit people that have bias. Somebody blurting something out to the panel that may poison the panel, like, yeah, I can't serve because my wife got, murdered by a guy 2 years ago and it was horrible. You don't want that getting to your jury panel. So what I typically ask the judge to do is in certain questions, ask the jurors not to respond verbally, but just to raise their hand and ask him to take them up to the bench individually so they can talk to the judge and the attorney with the court reporter listening, so we can hear their answer and their position without having to, for it to be heard about the entire panel. So exactly. I found that to be very, very effective in cases like that.
100% it is. Write down their number, make a little note to yourself, and then question them privately where everyone can speak freely. John